problem today is that we face major challenges in many respects that rely and that have as a prerequisite a financially sound and solid state. And that financial soundness and solidity depends on a very small group of, for the most part, relatively rich investors from relatively few industrialized countries.
It is your taxpayer money that is being used to subsidize these preferential recoveries from holdout creditors. Do you really wish it? Do you wish to explain to your taxpayer where their money went?
Right now we have a system where a country at its worst moment is responsible for basically coordinating all of these people who have no incentive to write off their claims. I mean, that's a little upside down.
We are in the middle of a sovereign debt crisis in the global south, threatening a lost decade of development. Debt relief is very high on the political agenda, but the mechanisms to resolve sovereign debt crisis are insufficient. Private creditors are the most important creditor group when it comes to countries in the global south, but most of them refused to participate in debt restructurings. Therefore, there are discussions about how to improve the participation of private creditors in debt restructurings. Among the discussions are mechanisms to enforce private creditor participation, such as national legislation. And this is what we want to talk about today in this video with three eminent and very long-standing experts in the debt restructuring sphere. Enjoy the video.
What problems are inherent in the current debt architecture when it comes to comprehensive creditor participation?
Well, the problem is that currently there is no comprehensive debt restructuring framework at all. There is only a certain practice which has evolved over time, and that practice is highly unreliable, and that practice is not comprehensive. So quite effectively speaking, there is no means how private creditors can be forced to participate in a debt restructuring, that you will only get a debt restructuring under conditions that are acceptable to a vast part of the majority creditors. So that means we're giving an enormous amount of political power to investors from a different country, power over the fate of a state and of thousands of people affected by a debt crisis.
This was a problem back in my crisis, every crisis. By the late 1990s, the Paris Club might have been just enough to incentivize some private sector participation. A lot of the creditors who matter now are not part of that framework, not invested in that framework. In a world where you have the Paris Club and the G7 and the IMF and the World Bank and all of these institutions where more or less the same set of actors, the rest of the world may feel compelled to listen, not so much because it's legally binding, but because the coordination creates a credible threat of response. Whereas right now, it's not really clear how much this particular set of actors, how much power they have, because there's so many different alternatives. So as a result, not only does China feel like, it's not clear why they should participate and what's in it for them, not only does Glencore perhaps not feel compelled to participate, but also the old bondholders and the old banks that might have been regular participants in several previous restructurings no longer feel compelled to do so. Right now we have a system where a country at its worst moment is responsible for basically coordinating all of these people who have no incentive to write off their claims. I mean, that's a little upside down.
No sovereign that issued bonds in the 19th and early 20th century cared very much about collective action clauses or anything else, because they had the ultimate sanction. They could not be sued. It wasn't until the last quarter of the 20th century, starting in 1976 in the United States, that absolute sovereign immunity was removed. And a new doctrine called restrictive sovereign immunity came into effect. And it says that when a sovereign enters into the international commercial marketplace and behaves like a commercial actor, for example, borrows money, then as a matter of law, that sovereign ought to be answerable for those contractual commitments in municipal courts as though it were a commercial actor. For the first time in history, sovereigns are susceptible to being sued by private creditors. And as a legacy of the history I've just recounted, the sovereigns are not entitled to any bankruptcy protection. For the first time in history, their creditors have legal remedies. So how to fix it? It's the same problem that a holdout creditor can extort a preferential recovery either from the debtor or from its fellow creditors simply by saying, I won't go along. And you need, unless you have some other mechanism to do this, you need 100% unanimous consent of all creditors to do the restructuring.
In the absence of an international insolvency mechanism, how significant are national legislation to make debt restructurings more efficient?
I think that they can play a really important role. Now, I think it's important to consider them in the context of the broader debt restructuring regime, right? So there is no law that is going to solve the problem.
Would it be good to adopt national legislation? I think definitely it would be worthwhile a try. Like, especially for individual countries that have a certain financial prowess, that have a financial influence, that are the site of many investors, and that are, to some extent closely linked to the major global financial centers, even if they're not a global financial center themselves. So I think that basically every EU state could contribute to that by adopting such legislation, or even make the EU adopt such legislation. Nevertheless, there are some practical problems and some, I would say rather theoretical problems. One would probably have to figure out if any court could intervene and could consider that as an, kind of an unjust measure, because it's a political decision that is taken a little bit of remote from the creditors, and that one might see, or that some courts at least might see as a disadvantage to creditors, that they're not willing to accept under a notion of contractual fairness or under a notion of constitutional as a matter of constitutional law. So that means that economically, I think, just to wrap that up, it would be a very sensible measure, and it would definitely be worthwhile trying it.
And I can tell you the argument that resonates most with politicians. It is that these holdout creditors are effectively taking their taxpayers' money. The governments, traditionally through the so-called Paris Club, the OECD countries, will provide debt relief to these countries. It is only by virtue of the fact that that debt relief has been given that the country could possibly give a preferential recovery to a holdout. Here's how I sometimes describe it. The Hausfrau in Stuttgart who paid her taxes winds up subsidizing the hedge fund manager in Greenwich, Connecticut. And that is an argument that politicians understand.
What risks do such national legislations bear?
National legislation only reaches as far as the nation goes. So it has a territorial significance only. And that means it will only be an effective means to stop private creditors from doing what they want or to force them into a debt restructuring if important jurisdictions like in the United States, like the United Kingdom, like Japan, but perhaps also like Germany, participate in that. That also means that a country like Germany would have quite some symbolical leverage in adopting such a law. But there is a practical problem that goes even beyond the United States and the UK, because what could happen is that you easily outsource the legal part, so to say, which means that you're going to a legal safe haven. Any country could adopt a law that is much more creditor friendly, and then live on a very tiny margin of the transactions that are funneled through them. Of course, that is not something that goes without saying. That country would have to establish enough credibility for that, but we've seen that in so many other fields.
Some people would worry that a creditor might go to Singapore and try to sue there, but I think those are workable problems. The anxiety that all of these cause to politicians is, will we be seen by legislation to interfere in the market in a way that discourages people from lending to these countries?
Right.
And of course, to do that is to actually harm the people that you're trying to help.
Mm.
But let me say one thing, because I hear this all the time. People will say, "Oh, limit remedies. My heavens, you would destroy the asset class," I believe is the phrase.
Mm.
And my response to that is, friend, for 100 years, we have had Chapter 11 in the corporate world. The fact that every lender to every corporation in the United States knows ex ante that in a debt distress situation, they might be subject to the decision of the supermajority of their fellow creditors. That has not inhibited lending to corporates in this country. I think that is a false argument.
As far as governments interfering with existing contractual rights or property rights, different legal systems are different, but as a general matter, bankruptcy laws are an organized way to interfere with contractual and property rights. I mean, that's right. So a bankruptcy law is a law for breaking contracts in a collective, comprehensive, equitable fashion that we agree on as a matter of public policy and kind of social consensus. So I think that, again, it's not there may be technical issues that can be resolved in particular ways in particular legal systems. None of these are insurmountable. I mean, my concern is that in these debates, and this goes back to what we started with, back in my crisis, it's a lazy Pavlovian response to say, this will raise borrowing costs, this will kill market liquidity, this will, violate some abstract right. Are there risks? And I would very much want to emphasize, I don't disagree that there are risks, but generic arguments are not risk analysis or risk management, right? So I think that, anybody advancing a generic argument has to contend with the question of, why do we have bankruptcy laws and how come that hasn't killed markets? And in fact, that's increased predictability. And also, frankly, social consensus, right? I mean, it's really, and moreover, if I'm a private creditor, what I want right now more than anything is, treaty-based sovereign bankruptcy.
So we would have, let's say, somehow a meeting of London lawyers and country representatives and industry representatives that somehow, behind closed doors, perhaps, or ideally in an open court, but still in England, make up a plan for a country on the other side of the earth. Yeah, that is not really an ideal situation if you are favoring a fair and just world where every country has an equal say and where ultimately every individual person counts the same, regardless of their economic situation, because it's always political. Yeah. So I hope you can see that I've got some technical, practical concerns and some, I would say, more political, maybe even ideological concerns relating such procedures, but still, of all the many non-solutions that we've seen in the past, if that solution of domestic legislation was available, I think it would mean as such a clear progress.
What elements should anti-holdout laws cover?
I think that the UK HIPC legislation was very narrowly targeted. So that law was very clearly drafted to say that you cannot recover more than the government would have recovered had it had this claim. So that I think that's important, rather than, for example, looking at who bought the debt for how much. All you're saying is we do not want citizens to subsidize recoveries by a small subset of creditors. And I think national legislation that limits recoveries to an equitable proportion, right, is something that is worth considering as a backstop, right, to these other institutional mechanisms.
I think the English law, again, it applied only to HIPC countries. But I think that has been regarded as a success. Why? Because many of the HIPC countries were African countries, and most African external debt is governed by English law. So it was effective. That approach always made a great deal of sense to me. You gave debt relief because the debtor country was in financial distress. This was an international effort. The IMF is requiring fiscal adjustment in the country. There is burden sharing all around, except for this holdout creditor who is exploiting the generosity of your taxpayer. And I thought the English law was very clear that that's what it was doing, because it didn't say you couldn't go to court. It simply said you may not get a recovery greater than the English taxpayer has received in this country.
And then there's something that I've been advocating for a very long time, and it was included in the Group of 30 report about a year ago, is shielding payment systems. Payment systems in particular are incredibly valuable for enforcement. So if you're a creditor, you don't want to ship, you want money. Where's the money? The money is in the banks. And so if you enjoin an intermediary that is transferring a payment either to other creditors or for, imported food items, right? Then you both harass the government into settling and you satisfy your claim. And we've seen a number of cases where this has been the pressure point. So shielding payment systems, the way that Belgium did, the way Belgium shielded Euroclear, I think is extremely important and valuable. So those three elements, I think, are really well suited to national legislation, right? Proportional recovery, asset immunity, and shielding payment systems. And that's where I would focus.
To discourage holdout creditors by limiting their enforcement rights. So this theory says we will not try to limit the ability of a holdout creditor to get a court judgment, but holding the judgment, how can they enforce it? If they get a judgment, they may not attach the sovereign's assets in specified jurisdictions. Well, that doesn't change the creditor's legal rights, but it does change their remedies. And the argument in favor of this is all of our laws, and I mean all of us, United States, UK, Germany, France, everyone, has sovereign immunity laws that already clothe certain sovereign assets with immunity. The final category, and this is something I've proposed just in the last couple of months, would be to codify what I think of as a widely accepted implicit duty of all creditors of a sovereign, or all creditors of, frankly, an entity that is not eligible for bankruptcy treatment, that if that sovereign finds itself in financial distress, unable to service all of its obligations, that then everyone has a duty to cooperate in the workout for that sovereign, and to break ranks, to seek a preferential recovery in that situation is, quite honestly, just another way of saying, I wish to exploit the generosity of my fellow creditors, whether government or commercial, in order to enrich myself. And I think we have come to the point where the vast majority of creditors, both official and commercial, would agree that that is unacceptable behavior. And one could codify it in domestic legislation.